Welcome to Law Family. This video is helpful to the law students and newly practicing young advocates only. Today, we discuss about the sections 101, 102 and 103(1) of BNS Act 2023. Corresponding law is 300, 301 and 302 of IPC. Again, 300, 301 and 302 of IPC. Murder. Evidence proof that the death of a human being has actually taken place. The murder has been committed by someone is essentially to be proved. Second one is that such death has been caused by or in consequence of the act of accused, where there is no evidence to prove that the accused had anything to do with the death of the deceased, no conviction could stand. Where the medical evidence does not support that the deceased met with a violent death, no charge of murder can be brought home to anyone. Third one is that
that such act was done with the intention of causing death, or that it was done with the intention of causing such bodily injury as a. the accused knew to be likely to cause death, or b. was sufficient in the ordinary course of nature to cause death, or that the accused caused death by doing an act known to him to be so imminently dangerous that it must in all probability cause a. death, or b. such bodily injury as is likely to cause death, the accused having no excuse for incurring the risk of causing such death or injury. It is necessary to consider whether the accused must have known when committing the act that first one is it might possibly but was unlikely to cause death or injury sufficient in the ordinary course of nature to cause death. Second one is it was likely to cause death or injury sufficient in the ordinary course of nature of cause death. Third one is it probably would cause death or injury sufficient in the ordinary course of nature to cause death.
three stages. First stage is if the act falls within the first category, it would not amount to more than hurt or grievous hurt. Second one is second stage. If under the second category, it would be culpable homicide not amounting to murder. Third stage is if under the third category, it would amount to murder. Medical evidence does not support the prosecution's case. If the prosecution's medical report is weak or uncorroborated, or if the doctor who authored it is not examined, the court may acquit the accused because the report fails to prove key elements like the cause of death, the discrepancies Important point here is the discrepancies. Discrepancies between medical and eyewitnesses accounts can create reasonable doubt leading to acquittal. The prosecution bears the burden of proving guilt beyond a reasonable doubt, and failure to establish cohesive chain of evidence, including medical evidence, result in acquittal. Incomplete or inconsistent medical findings. If the medical report is vague or fails to establish facts essential for proving murder, that is, a clear link between the injuries and the weapon, or the intent to cause death, the prosecution's case will be weak. Creation of reasonable doubt. Discrepancies or gaps in the medical evidence can raise reasonable doubt about the accused's involvement. Medical report is generally not substantive evidence. Circumstantial evidence. All pieces of evidence must form an unbroken chain pointing to the accused's guilt. Weak medical evidence breaks this chain. Lastly, a good lawyer in a murder case absolutely needs to understand medical terminology and medical evidence, as this knowledge is crucial for effectively challenging or presenting evidence related to the cause of death, nature of injuries, and other medical facts. Lawyers must be able to analyze reports from medical experts and forensic reports to understand complex medical issues, which can mean the difference between a conviction and an acquittal for their client.
Punishment section 1031. The punishment for murder is death or life imprisonment along with a fine, cognizable, non-bailable, triable by the Court of Session. This video is purely theory. The Honorable Court decides each case on merits. Thank you.
Thank you.